bankruptcy. But the house was not included in any of the bankruptcy filings. But she still living in the house, and she knows that she bad. She just had other problems before we got married. So it's that. Like, I think you better take it. Okay, okay.
I know just generally you're supposed to include all assets and all liabilities. So I don't know what repercussions we have for that. I can't imagine that it would, but I mean, there could be some provision that assets withheld, revert to the trustee or something like that.
Because she's still paying the mortgage
Right.
on my house. And they said, well, pay it off. You still own it, they sell it. And that's concern, because we want to try to pay it off. Sell it.
I'll just do a research and see if I can, or see who I can tell you to call.
Appreciate you, man. Thank you. No, thank you. It's not.
This meeting of the Escambia County Board of Adjustment on January 21, 2026 is hereby called to order. With 5 members present, we have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for January 21, 2026 with the Development Services staff findings of fact have previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
Motion.
Motion made by Willie. Second by Susan. All those in favor of the motion, please raise your right hand. And it is unanimous, 5-0. The motion passes. Madam Clerk, do we have proof of publication?
Yes, sir.
Did the publication meet all of the legal requirements?
Yes, sir.
The chair will now entertain a motion to, pardon me, waive the reading of the legal advertisement. Do we have a motion?
Motion.
Motion by Willie. Do we have a second?
Second.
Second by Ross. All those in favor of the motion, please raise your right hand. And it is unanimous, 5-0. The motion passes. Members of the board, have you reviewed the minutes for the Board of Adjustment meeting held on December 17, 2025? Upon your review of the minutes, are there any additions, deletions, or corrections? Seeing none. The chair will now entertain a motion regarding the minutes for the Board of Adjustment meeting held on December 17, 2025. Do we have a motion?
I make a motion, we accept the minutes.
We have a motion from Susan,
Second.
a second by Willie. All those in favor of the motion, please raise your right hand. And it is unanimous. The motion passes. Willie, would you please read the purpose of the Board of Adjustment and conduct of the meeting?
Purpose of the Board of Adjustment and conduct of meeting. The Board of Adjustment, BOA, hears administrative appeals, variances, and a conditional use request. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, that anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of a development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for the properties in the ordinance with the decisions of the BOA. However, if the applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decisions by filing an appropriate pleading in the court of a competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on a table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
Ex parte communications. All written or oral communications outside of this hearing with members of the Board of Adjustment regarding matters underway reviewed today are considered as ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commissioners, Resolution 9613, before a decision by any board member on any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. All right, we have first case number CU 2026-03, 1420 West 9 Mile Road, a conditional use request to amend the operational hours of approved case CU 2025-10 for on-premise alcohol consumption within 1,000 feet of a child care facility, requested by Meredith Bush, agent for 9 Mile Phase Plaza, LLC owner. Does any board member have communications regarding this case? Seeing none. Does any board member have knowledge of information obtained from a site visit or other sources? Seeing none. Ask board members if you intend to refrain from voting due to a conflict of interest on this case. All right, would the individuals who are a party to this item please come to the podium and state your name and address for the record so that you can be sworn in by the clerk.
Good morning, Board. Meredith Bush, 314 South Balin Street, Suite 108, Pensacola 32502. And I'm typically not sworn.
All right. Have you been provided with a copy of the criteria required to obtain a conditional use and a copy of the findings of fact?
Yes.
And you understand that all the criteria must be met in order for the Board of Adjustment to grant a conditional use?
Yes.
Does the board have any questions for the applicant? Do you want to present findings of fact, or would you
Sure,
rather
I
have
can,
staff do it?
I'm happy to briefly go through. This is a case where we are in agreement with staff's findings. Staff is recommending approval. You may recall, we were here last year seeking a conditional use, which you granted, to allow on-premise consumption of alcohol at the Pelican. It is located adjacent to, but across a retention pond from Little Prodigy's daycare center. We've since come back with this revised or amended application seeking to allow the expanded use, the on-site, on-premise consumption indoor of alcohol during hours when the school is closed. So on recognized holidays and weekends, when there's no overlap or conflict of uses, we're simply asking that you expand the previously granted conditional use to allow that additional service at our facility. And that really is the only difference in criteria from the prior package that you approved last year. And I'm happy to take any questions.
Questions from any board member?
Ms. Bush, with respect to holidays, is it federally approved holidays, or can you elaborate on that?
So we said holidays recognized, in our submittal, holidays recognized by the Escambia County School District, although Little Prodigies is a private school, and listed in our application, the standard Florida school closure holidays would include New Year's Day, Martin Luther King Jr. Day, President's Day, Spring Break, Memorial Day, Independence Day, Labor Day, Veterans Day, Thanksgiving break, a winter Christmas break, Good Friday, and Easter holidays, and then any professional development or teacher work days. But it would be, in conjunction with whenever Little Prodigies is closed. So we would have to, get from them their dates, and it would only be the additional sale of alcohol for on-premise consumption when the school was actually closed.
Other board questions? Staff, would you take us through the findings of fact, please?
Certainly. Caleb McCarty, AICP planner on behalf of the county. First, we'll have some maps and photography here. This is our location map showing the location at 1420 West 9 Mile Road. This is our 500-foot radius zoning map. The zoning is heavy commercial, light industrial, HCLI. The future land use designation of the property is mixed use urban. This is our site distance map that we reference in our findings that shows the relation of the proposed use in relation to the conflicting use of the child care facility. This is an aerial showing the location. The building is actually up now, I believe. So, our notice of public hearing sign that we posted out front along 9 Mile. Yes, this is looking onto the site, as you see, under construction. Again, looking onto the site in reference, you can see the corner of the other building to the right-hand side, where the child care facility, there is an extensive retention pond that is currently under construction between these two buildings. And that shows it there. This is the adjacent development as reference. This is looking east along West 9 Mile Road. Also looking east, another photo. This is looking across 9 Mile Road there towards some apartments. This is looking south across West 9 Mile Road and looking west. That completes our maps of photography. If you'd like, I can proceed into a summary of this item. So, remember, previously the conditional use for this property, to remind the board, was under KCU 2025-10. In particular, it was to allow for on-premise alcohol consumption within 1,000 feet of a child care facility. Per the previous case, the BOA granted the conditional use with the applicant's amendment of the operating hours to reflect package sales to start at 10 a.m. and the bar services to start at 3 p.m. Monday through Friday and 2 p.m. Saturday and Sunday. That's what they were approved for originally. This amendment request is seeking to expand the operational hours for on-site alcohol service, specifically to weekends and holidays for hours during which the child care facility is not operating and are otherwise closed. So at this time, the amendment to the previous case did not change our findings. So we still recommend approval based upon the criteria of the Land Development Code, and that would be up to the purview of the Board of Adjustment. So specific to the previous case, it's an amendment.
Does the board have any questions for staff? We have one person from the audience, Buddy Stromberg. You here?
That is for the, one of the last cases, not this case.
Oh, I'm sorry. Out of order. Okay.
I don't believe we have any speakers.
Yeah. Okay. Any questions for the applicant? Okay. Board members recall the request for conditional use and the discussions we had. And this is only for expanding the hours for liquor use. All right. Having no other questions,
Mr. Chairman?
Chair will now entertain a motion regarding,
No, that's what I wanted. I was gonna say, if there's no further discussion, I'd like to entertain a motion to approve according to staff's findings, based on the fact that both neighbors, they have been working together. When they came in here, you know, it didn't seem to be that way at first, but they came together and they have been working together, and I don't see anybody in here opposing, and so I would like to make a motion to approve according to staff's findings this morning.
motion by Willie, second,
Second.
second by Susan. Please raise your right hand if you are in agreement with this motion. Motion passes unanimously. All right, second case, number CU 2026-05, 4524 Softly Field Road, a conditional use request to allow outdoor storage of trailer boats and recreational vehicles, requested by Tom Harmon, agent for Northwest Florida AC LLC owner. If the applicant would approach the microphone, please. Okay. Please state your name and address and be sworn in by the clerk.
All right, Tom Hammond, Hammond Engineering, 3802 North S Street, Pensacola, Florida, 32505.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Board members, are there any ex parte communications regarding this case? Seeing none. Is there any knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest?
No.
Seeing none.
And if I may, sorry for the quick interruption, just in case if there are any technical questions from the engineering, Mr. Hammond has presented to this board as a subject matter expert. So okay, box form, but he has presented engineering questions as a subject matter expert to this board on many occasions. So just in case if that come up about the site plan and stormwater engineering.
Thank you.
Definitely has possessed a subject matter expert. Has been qualified as well.
Have you been provided a copy of the criteria required to obtain a conditional use?
Yes, sir,
And you have a copy of the findings of fact?
I do.
Would you like to make a presentation, or
Well, I'm thinking it'd be pretty short, because even though they're worded different, our findings of fact agree with the county's findings of fact. So we can make this short if y'all want to, or I can walk through it.
board? Would you like this?
If it's okay with the board, I think it's time to hear from staff at this time, you know.
Okay.
All right, Andrew Homer, Escambia County Development Services. This is conditional use 2026-05. Here we have our location map. You can see it's on Softly Field Road, just to the west of Mobile Highway. This is a zoning map. You can see it is split zone. The majority of the zoning down in that area around that intersection of those two arterial roads is commercial. Future land use map shows the entire parcel is commercial. This is an aerial map of the site. For those of you familiar with the area, this is just to the west of, you've got a McDonald's there on the corner, I believe a CVS. Next, thank you. Public hearing sign posted on site. That's looking back east along Softly Field Road. This is looking north onto the subject property. Again, looking north and looking northwest from Softly. All right, as to the staff findings, Mr. Hammond stated, staff is recommending approval, and I'll go through these one at a time. This is a conditional use request to allow outdoor storage. As to the first criterion, this is dealing with general compatibility. Subject parcel is located among commercial and other mixed uses, and is along a minor arterial road within a quarter-mile of the intersection with a primary arterial road. The proposed use can be operated in a manner compatible with the surrounding uses along this commercial corridor. Second criteria is dealing with facilities and services. They are available and will be provided as needed for the proposed use. Connection to those services will be reviewed during development review. Third criteria is dealing with on-site circulation. Ingress and egress will be via a connection to Softly Field Road and an internal drive. Specific connections will be reviewed during that development stage. Fourth criteria is dealing with nuisances and hazards. The proposal is for a relatively low-impact land use and shouldn't generate nuisance conditions for the neighboring parcels. Fifth one, solid waste. Solid waste service must be provided as needed for the proposed use. Six would be criteria, screening and buffering. Comments from planning staff related to screening and buffering for the proposed development were provided to the applicant during development review. They did a pre-application. If the conditional use is approved, the applicant must meet the screening and buffering requirements of the Land Development Code. 7 is dealing with signs and lighting. Signs and lighting will be evaluated and will be limited to what is allowed by provisions of the LDC. Exterior lighting shall be deflected from adjoining properties and public streets. 8, this is site characteristics. The site appears adequate for the proposed use as it is level and not constrained by any natural physical factors. And 9, specific use requirements. No repair, overhaul, or salvage activities are allowed, and the storage must be screened and maintained to avoid nuisance conditions. For the findings, staff recommends approval of the proposed use as requested with the condition of completion of the DRC process and receipt of a development order.
Does the board have any questions for staff? Does the board have any further questions for the applicant? Would the applicant like to add anything to?
I would just say that there's a lot more intense use could be done on this based on the zoning than what's gonna be what we're proposing. And I'd ask for y'all to approve it. Thank you.
All right, we have one,
No speakers on this case, Mr. Shack.
pardon?
No speakers on this case. Only the applicant.
Oh, okay. All right. The board has no further questions. Chair will entertain a motion regarding CU 2026-05. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff's findings and provide substitute findings.
Mr. Speaker, I move that we accept staff's recommendation.
We have a motion to approve.
Second.
And we have a second. All those in favor, raise your right hand. And it is unanimous. The motion passes.
Thank you.
All right, case number CU 2026-02, 5490 Cruzat Way, a conditional use request to allow an accessory dwelling unit on a lot less than 1 acre in MDR zoning, requested by Meredith Bush, agent for Renata, I'm sorry, I'm going to butcher this name, Chuodzek. Board members, is there any ex parte communications regarding this case? Seeing none. Is there any knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are a party to this item please come to the podium and state your name and address for the record so you can be sworn in by the clerk? Meredith, you have already been sworn in.
Yes, thanks. Meredith Bush, 314 South Balin, Suite 108, Pensacola, 32502.
Board, any questions? Do you want to, do we have findings of facts on this one? Okay, would the staff, would you staff present findings of fact, or?
That's fine if the staff wishes to go first. This is another case on the conditional use where we agree with staff's findings and they're recommending approval of the conditional use. But if you'd like them to present, then I can, follow them with our, very similar findings.
Okay. Staff, would you present findings of fact, please?
Yes, sir. Kimberly Wilson, Senior Planner. So this is for conditional use, case CU 2026-02, 5490 Cruzat Way. So the requested conditional use is for an existing accessory dwelling unit to be located in the front yard of a waterfront lot. The lot is also less than 1 acre. And they're also requesting, in conjunction with this, a variance for the required setbacks for the actual ADU in the lot. So here we have the location map. Next map, we do have the radius zoning map. Next one is the future land use map. This is the flood zone map. It's an aerial map. This is our sign of notice of public hearing. This is looking northeast onto the parcel and the property, or the ADU. This is looking east onto the property. Looking north from Cruzat Way. and this is looking onto the subject property. Okay, now for staff findings, going through all the criterions. Criterion A, general compatibility, finding of facts from staff. The applicant has submitted a site plan and a sealed survey showing an existing accessory dwelling unit located within the front yard of the property. The proposed use is capable of being conducted and operated in a manner that is compatible with the adjacent properties and the character of the surrounding neighborhood. Criterion B, facilities and services. Public facilities and services are available to serve the subject parcel and are currently being utilized by the applicant. On-site circulation, ingress and egress. The property is located along Cruzette Way. Proposed use will not adversely affect traffic circulation, pedestrian safety, or emergency vehicle access, and is consistent with the functional use of the roadway. Criterion D, nuisance and hazards. The applicant has represented that the proposed accessory dwelling unit, ADU, will not create nuisances or hazards for the adjoining properties. Approval of the conditional use would allow the applicant to exercise residential rights consistent with the other homes in the surrounding neighborhood and while remaining compatible with the character and use of the area. Criterion E, next, solid waste. Based on the submittal application, solid waste collection services are currently provided to the subject property by Emerald Coast Utilities Authority. Screening and buffering, criterion F. Proposed use does not require additional screening or buffering, as both the use and the zoning of the property are residential and compatible with surrounding properties. Signs and lighting, criterion G. The applicant has stated that no signage will be placed on the structure and that any exterior lighting will be designed and operated in a manner that will not create a nuisance to neighboring properties. Site characteristics, criterion H. According to the county GIS system, the site is located within an AE flood zone. If conditional use is approved, the applicant will be required to submit construction plans that comply with all applicable standards for development in a FEMA-designated special flood hazard area, as outlined in the Land Development Code and the Florida Building Code. Use requirements. The existing accessory dwelling unit, ADU, is subordinate to the principal dwelling and is located on the same lot. Additional requirements may be applicable and will need to be addressed by the Escambia County Building Inspections Department. In conclusion, staff findings. Based on the review of the submitted material and applicable Land Development Code standards, staff recommends approval of the conditional use as requested.
Does the board have any questions for staff? Does the board have any additional questions from the applicant? All right, we have several people in the audience that want to speak. Buddy Stromberg. Please provide your name and address and be sworn in by the clerk.
My name is Buddy Stromberg. I live at 5671 Cruzette Way.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, I just noticed all this was coming down, and I'm trying to find out what building are we talking about to allow an accessory dwelling unit and then a side yard setback variance on this property. I mean, how big is the building gonna be? Where's it gonna be set at?
It's the existing building.
What existing building?
It's already built, it's the garage, the second.
That's the one that was supposed to be a garage. It's a rental unit now, right?
It's not a rental unit.
Okay.
It was approved as a garage, yes,
Okay.
sir.
All right. Another question while I'm here. If you look at the garbage can up here, there's a no parking sign there. And there's also a wooden picket with a chain link gate right there. that was put in back a while back. What I'm gonna see about doing while we're here is to get them signs removed so the people that live there on Cruzat Way can actually go down there and use the waterway like we used to. Now, they had a thing going back in 2017 for some kind of setback. I forget what it was exactly. I think it had to do something with that building that you were talking about there. But until we can see more outstanding what the heck's going on, you know, give the community time to research what they want them to do. I think you mentioned something about they got to put in plans for what they're going to be building. Is that correct?
Yes, sir, they would. The ADU is already built. So the structure that she showed you on the screen, it's already built. Just backstory history on it, you are correct. Several years ago, it was approved for an accessory structure, a garage in the front yard, okay? But the variance was denied because I believe they were asking for it to be less than 60 feet from the property line.
Right.
So that portion of it was denied, but it was approved for the garage in the front yard.
I remember that.
So it's already built.
That part. But I was just confused about the other parts. I mean, how big is this other building going to be?
So the main house is already there as well.
Right.
That's built. So these are structures already built, okay? It's no new building. They're already built.
Oh, okay.
Yes, sir.
All right.
Okay.
So what can we do about getting them signs removed down there at the end of the road?
So that is unopened county right-of-way.
Yep.
Free for access to all. There should be nothing blocking it.
There's bollards blocking it.
They can't have bollards.
Bollards were put in there, right up there. Stop your mouse. Come on, back up, right there. They were right there.
The only thing that should be in there is things permitted by the county. And when I went out to post the signs, I didn't see anything we had installed. So the other stuff would need to go.
County,
that would be.
The county installed those bollards.
Yes. The other, any kind of fencing, gating, what have you, installed by a homeowner would need to be removed.
Okay, thank you. That's what I
You
wanted.
indicate that the county installed them, so if the county installed them.
Well, the
Mr.
county didn't
Homer-
install the signs, is what I'm saying.
Correct.
Bollards they did, so
Okay.
Mr. Homer, you can work with him on that, and he can get with the other about
Okay.
the signs and things like that. That's not for this board purview.
Okay, all right, thank you.
Thank you. Board, any further questions? Okay, we have Mary Innebert, if I pronounced that correctly. Please state your name and address and be sworn in by the clerk.
Marion Abnett, 14435 Gorham Road.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good morning.
Okay. Good morning. I don't know how my visuals can be seen. I guess I should have brought them as digital. Can I just hold them up?
Sure.
I was invited here by public hearing notice. I live right across the street. And this is just a pictures of the end of Cruzat Way and how it has been used for generations. And it is public access. And I wasn't sure what exactly was going to happen there because land has moved around and people have moved and new people have moved. And so my concern is that our water accesses, there's one on Bobolink and one on Cruzat, which were the reasons why I moved there, because I could put my kayak in the water, and now I'm living my best grandmother life. My grandkids are coming down, and we go down there. I'm teaching them to fish and kayak. I have 2 4-year-old grandsons. And there have been no parking signs put down there. And so my concern was that maybe somehow neighbors are trying to acquire that property, and I don't know who to even talk to, but this was a concern. And on here, one of these is a side yard setback variance. Is that a side yard, or is that, I would just like it to be acknowledged here today that those are public accesses, and we're not trespassing if we use them.
Let me. So.
And there's no intent to vacate.
So
Who's that?
Correct. That is county right-of-way, all right, all the way to the water, free and clear, open to all. The only way that someone could ever block, take possession, what have you, of county right-of-way would to seek through the county commission a vacation of the right-of-way, at which point half would go to the owners on either side. No one has sought that here. And frankly, the county commission has, over the years, declined to vacate anything that provides public access to the water.
Commissioner Doug Underhill and then Jeff Burgosh.
Correct, and it goes back,
That was going to remain that way.
correct, not even just that one district, but countywide. They have not been amenable to any requests to vacate any sort of public access.
But there have been attempts to put in rocks and oyster beds and all sorts of things that would really discourage entry into the bay there, because
Correct. Nothing should be going on there that's not being done by the county.
requested to do anything of that.
No request.
And this is, and this we want to be clear, this is on his property per se. And again, as Deputy Director spoke, those matters will be handled. If there's any action on that, they will be handled by another board under another purview on that part. But we'll be glad to give you those contact information, Mr. Tim Day, or anything concerning public beach access. We'll be glad so that you can stay informed. You can stay in the loop on those matters.
That would be good.
Yes, ma'am, we'll be glad to, because you do have the right to know about those public beach access. But in this purview, as you stated, it does not have, if there's any barriers or anything like that, Mr. Andrew Homer here work with our other department who's over that to see if those things can be cleared up per se. But his case is specifically with his case, conditional use and variance on his lot. That's where he's being represented by the attorney. If there's anything that's not factual, his attorney will have to work it out.
Okay. Well, there's just been a lot of land moved on that property. It moved forward into the bay, and then Gorham Road used to go across, and that land was vacated. So, I've watched all this happening, and me and some of my neighbors get concerned because it's really a very friendly and quiet neighborhood, and we just want it to remain having the water access and nature of the area that we love.
Thank you.
Okay, thank you so much.
Does the board have any questions for the speaker? All right. Chair will now entertain a motion regarding item CU 2026-02.
Wait, we have more.
Oh, I'm sorry.
Another speaker. Yes.
Javin Montgomery.
You can speak. Your board can speak. Well, after, yes.
Okay. Unfortunately, I'm sorry that I'm here today because
Mr. Chairman.
yes.
Would you
my name
please
is
state your
Javin
name and
Montgomery.
address?
I apologize. My name is Javin Montgomery. I live at 14430 Gorham Road. I am 2 doors from this property on Gorham Road.
Please raise your right hand.
Yes.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may go ahead.
Yes. Again, I'm sorry I'm here today because unfortunately this person is my neighbor and I don't want to go against him. However, the way he handled this and the way this has been done is completely bamboozled everyone in this entire room and everyone in this entire situation. And I am very upset at how he handled the situation. First of all, I'd like to understand and let everybody know that I consider myself to be an expert in real estate. I've been in real estate for 25 years. I currently own, operate, and manage over 437 units across 3 different states, and 260 of those units are here in Escambia County. I am a developer, I'm a real estate expert, I'm a real estate broker, as well as this is my home. This was where my parents live right now, and I consider this to be my retirement home. And the way this was developed and the way this was operated was completely against code, against what was the use of this property and how this developer, Albert, actually went about this. And I actually brought this to the attention of code enforcement and the board, everything, when it was being built, because I was concerned that he lied. 100% he lied. And that building there, if you can point to the accessory structure that we're talking about, this is the accessory structure. I want everyone to look at in the front of that. That is supposed to be a garage. It was permitted as a garage. How do you fit a garage through a window? I'm sorry, how do you fit a car through a window? You don't. It was never intended to be a garage. He actually built it as a tiny home. And he built that as a tiny home before he finished the house on the water. If everyone will look as well, there's another home in front of the accessory, which is a 2-story home. And that is, you don't see it in the picture, but it's all the way to the right, okay? And that is the accessory home that he actually took the lot and he split it. And then he built a brand new home, 2-story home, on the one side of the lot. Then he took the existing single-family home and he moved it down the street all the way down to another lot that he bought, because he was trying to make this as many use as possible, and he basically overused this lot. And when he built this, which is upsetting to me, is the fact that he never built that as a garage. He never intended it to be a garage. He never put a garage door in there. You could never fit a garage in there or a car in there from day one. And unfortunately, what he's done is he's taken one piece of property and he's built another home, then he's built his waterfront home, then he's built a tiny home on this property, and it's wrong. This is not an existing building. When he built this dadgum thing, it should have been permitted only as a garage. And I called the building, I called everyone and said, listen, he's building it as a home. He's not building it as a garage. And he's putting a bathroom in it. He's putting a kitchen in it. He's putting a living room in it. And he's putting a bedroom in it. The last time I checked, a garage does not have those type of amenities and those type of facilities. I'm like, the thing that he didn't put is he didn't put one blamed garage door from the time he built it. And he lied to the permit board, to everyone, and basically tried to bamboozle his way in. And he went with the, I want to ask forgiveness rather than permission, because he knew he would never get it approved as a living structure. So now what he's done is he's basically bamboozled everybody, pulled the wool over his eyes, and basically bamboozled everyone over here and said, hey, well, again, where was the garage door? Where was it ever used as a garage?
We will have commentary, Chairman, but we'll have commentary.
It should have never been allowed, and please do not allow this to happen. I'm upset at how he did this. He bamboozled everybody, and he should not be allowed to use that as an accessory building for a living structure. It's wrong, 100% wrong.
Can I ask what the timing was?
Sir.
Yes, sir.
Just asking staff
Okay,
so
he's
you're
asking
not-
staff, you're not asking me?
In
He asking
Jan-
staff, us, so you can have your seat. He's asking staff.
Okay.
You can have your seat, please. Thank you.
In January 2021, the request came forward to this board, and it was granted. It was conditional use to place an accessory structure, a garage, in the front yard of a waterfront lot. Building inspections, as this progressed, alerted our department and said, hang on, this is living quarters. This isn't a garage, which was what it was approved for. One of the conditions at that point was when you're dealing with structures in a flood zone, a garage is not living space. It can be vented if it's below the proper elevation. Building inspections required an elevation certificate to see if this structure as it is now met the proper requirements, because a living space is completely different than a garage. They did meet the elevation requirements, but then are having to come to this board yet again now that it is an accessory dwelling unit instead of the originally approved garage. So that's what got everyone to this point.
And if I may, yeah. If I may, board members, I do understand his compassion, his passion about this, but I do want to address a few things. When the planning and zoning department and the building inspection department became aware of this ongoing issue, we stepped in immediately. Immediately. The holes were placed. We reached out to his attorney that he got to represent, and we had very, very frank conversations on this matter. Very, very frank, stern conversations on this matter. Holes were placed. Unfortunately, not to excuse any type of behavior, but to be factual. Incidents like this happen. Unfortunately, it does. I've been doing this over 20 years, and it does. Does it make it right? No. But it's our job to try to provide a pathway for compliance and to address any penalties that may be necessary. Does it happen? Yes. Do we like it? Unfortunately, we do not. And we've had very, very frank, hard conversations, hard talk. And much respect for Ms. Crawford, Ms. Bush on this matter. So this is where we are today. It's the board purview, the board decision. The conditional use, it met all of those standards, our pathway for compliance. It is in the hands of the board. There are holes in place. Staff, we move very, very quickly and assertively to get them to this point. Whether they're asking for forgiveness or not, that's up to this board. But this is what we're here. Does it meet the standards? In this case, it does. It existing? Yes, it is. Does it meet the standards? And our requirements, does it meet the minimum requirement? And that's what the code says. Sometimes I have to step out of mine and get what, based upon the codes and the property rights are available to all one, without negating the neighbors' concerns and issues at all. And we are not negating those concerns.
If I may address some of the comments made by neighbors and then also respond to staff's narrative. As far as the questions initially asked by Mr. Stromberg, there's no, and as outlined in our packet, there is no intent to construct an additional building. So we're talking about this structure you see that's already existing. So what's there is what we're referring to. As it relates to Ms. Engelbert's questions, the access to the waterway, this doesn't impact that. Bollards placed there were placed by the county, not by the adjacent property owner. I'm not aware of any signs, but, you know, we are well aware we can't place anything in county property, county right-of-way. So to the extent that, you know, if there have been signs there, it's my understanding they were not placed by my client, but, you know, we'll agree not to place anything in that access. As has been stated, we were before you. I wasn't representing the owner at the time, but there was an applicant here, counsel here for the applicant back in 2021, and the structure itself, the building was approved. Whether you call it a garage, a workshop, a shed, you know, it is an accessory structure and approved as an accessory structure. Because of the code at the time and the location on the lot, it had to come through the conditional use approval. And that goes to when you're on a waterfront lot, you know, what's the rear yard, what's the side yard, what's the front yard. It was granted the approval at that time. When we were initially contacted by the county and told, hey, this was approved as an accessory structure, not as an accessory dwelling unit, our first response to the county was, well, there's no intent that this structure be permanently occupied by anyone. The intent of the owner would be that occasionally his son's visiting would stay overnight. Yes, it has a bathroom. Yes, there's a kitchen. It's not going to be rented. It's not going to be occupied as a second full-time house. So, you know, our first response was, well, it's not a dwelling unit. We don't need the conditional use. After working with the county, we're like, look, to the extent that there may have been an error made prior to my involvement, we'll ask forgiveness. We will go through the process. We'll seek the accessory dwelling unit approval. We'll agree to pay 4 times the permitting fees, whatever we need to do to make this right. At this time, the structure's there. At this time, the, you know, internal facilities are there. We've already filed an affidavit with the county saying it's not going to be, you know, it's not a rental property. It's not full-time occupancy. And to, excuse me, so to the extent we've done everything that we know to do, as Mr. Jones said, to come into compliance, we're here to come into compliance. Your job as the board is to analyze whether or not we've met the criteria. If we have met the criteria, then you're bound by law to grant the conditional use. We have said we've met the criteria. The county has said we've met the criteria. Nothing presented in Mr. Stromberg's questions, excuse me, in Ms. Entelbert's questions, or in Mr. Montgomery's, you know, statements about how upset he is about this. Nothing in that impacts the criteria. Nothing in that shows that we haven't met the criteria. Nothing in what they've said constitutes competent and substantial evidence. And your job, again, is to look for whether or not there's competent and substantial evidence that we've met the criteria. So we're here saying we've met the criteria, the location, the, you know, access, ingress, egress, nuisance conditions, solid waste, all of the things, lighting, signs, all of the criteria in the code have been established. So we would ask for approval, you know, any commentary about a variance. Yes, we do have a subsequent application. First step is the conditional use. We're here right now on the conditional use. After this hearing is closed, you'll reopen another hearing, and that's where we'll talk about the variance. But the criteria before you right now are the conditional use criteria. For an accessory dwelling unit, it has been established. Again, we've agreed to pay additional permitting fees. You know, all we can do at this point is say the building is there. Obviously, there's no garage door on the building. We're asking that it be allowed to be used as an accessory dwelling unit with the understanding, again, it's going to be used for the current owner occupants, for their children when they come to visit. It's not going to be a rental property. It's not for full-time occupancy. And so if you have any other questions, I'm happy to take those. I know it's not a popularity contest, but there are members in the audience who are here in support of the owner who did not sign up to speak. To the extent that it matters, I would like the record to reflect that there are other people here who, you know, live close by and are not offended or upset by the fact that this property owner has lawfully developed his property.
Ms. Bush, before you sit down, board, any questions?
I have one.
All right.
Is this area, is it included in an HOA?
I would imagine so. No, there's no HOA. Okay.
Thank you.
I didn't know.
Just one quick question. How can you assure that it would not be a rental, Airbnb, with cash on the side deal type thing? How can you assure that? Or there's really no way to assure it. And I know you're here today to meet the criteria which you have met, but that was just a question,
There really is no way. I mean, so when you own property, you have, a bundle of sticks, those property rights, and you're allowed to rent out a residential unit in the same way that if they wanted to rent the main house on Airbnb or rent out individual rooms to 20 different people, you have those rights. It's not their intention to do that. Again, we've, filed sworn affidavits with the county saying we're not going to do that. But short of us just saying it, there's no way. I mean, the county can't tell someone who owns residential property that they're not allowed to rent that property on a long-term or a short-term basis. I mean, the law is very clear on that. And I understand, me saying, oh, this is not what they're going to do. That's, I understand your position or the neighbors who are upset, maybe their position that, well, we're just saying that. But just to be frank, there's nothing that you can do when someone owns residential property to stop them from renting it out short-term or long-term, unless, of course, there were covenants and restrictions in pre-existing the date of the most recent legislation that established those ownership restrictions, and that doesn't exist here.
Pardon me, would you clarify to the board, the initial approval, was that for a garage or an accessory dwelling?
So it was for a garage, an accessory structure. So the accessory garage phrase is not something that's in the code. What's in the code is accessory structure and accessory dwelling unit. A garage would be classified as a structure in the same way that a workshop or a shed or just a secondary building. The dwelling unit difference is that it has, the dwelling quarters, which includes the bathrooms and the kitchen facilities. So the initial approval was not for a dwelling unit. However, in the initial approval, and those records are in your backup, there was a sentence or two that said, and this property may occasionally be used as overnight dwelling or something to that effect. Which again, as I said, we went back and forth with the county initially to say, look, this was approved and we had this language in that initial approval. While yes, the overall intent was a structure, there was terminology that said it may be used in the future for this, and you approved it. But rather than fighting the county on whether or not that technically gave us the right already, we said, look, you want us to come in and go through the conditional use process, file the application, pay the application fees, we're just trying to make it right. We don't want the neighbors upset. We want to be good neighbors. We want to be good community members. And so that's why we're here. But in that initial approval that was for a structure and not a dwelling unit, it did have language that the, long-term intent was that this may be used in the future for dwelling.
And please let us, for the sake of clarity and for the sake of the record, we have a differing of opinion on that per the record. So what was approved and what was stated. So we can read the record and this is, but I'm glad Ms. Crawford came to.
Ms. Bush.
Ms. Bush, thank you. Thank you for the correction, please. I've been knowing you a long time. No disrespect. I came to the conclusion that the Land Development Code is right because there are clearly distinctive language on the difference inside the Land Development Code throughout on accessory dwelling unit and a detached accessory structure, which is typically a workshop or garage. This is what they asked previously. This is what the BOA granted. The BOA granted, and the language is clear and precise and in order. But we don't want to litigate that. But we just want the record Ms. Kim, could you please read that for clarity of the record?
So initially in 2021, I'm sorry. The approval from the board was for an accessory structure, detached garage, workshop, as Ms. Bush stated. Now, their language that they submitted, it said something, they may have the desire to potentially.
Right.
So, you know, the main focus on that approval at that time, it was not for a desire.
Right.
It was not for a potential. It was for specifically a detached structure. Yes. It was not for an ADU dwelling unit at all. Yes, you can mention that in your narrative. You can mention a lot of things, but the main focus will be on what you are actually asking for and not a potential or a desire. So that's what the board approved at that time, an accessory structure or a detached garage. And that's what, at the time, I do believe that's what drawings were submitted for just a garage. So even if you had that potential desire, your drawing said otherwise.
Right.
That you submitted to the building department.
Right.
So again, and like Mr. Director Jones is stating and Ms. Bush, you know, we are trying to create a pathway for compliance today.
Right. Please, if you want, because I can't hear. Thank you, Sir Q. Okay. And this is where we are. And again, Ms. Meredith stated that she was not representing them at the time, and as Kim stated so well, we review things and we grant per the BOA, and when they submitted plans for the approval, it was permitted that. But that's neither here nor there. The point is, the conditional use requirement, it does, according to the county, it does meet the standards. It does meet the standards. But now it's back into the hands of the board, how they want to proceed. But it does meet the standard going forward with the pathway. Not trying to defend, just trying to stay with the requirements of what I have to, if I go to court, stand and state for the records. The black and white language of the Land Development Code. Not my personal feelings, not my personal agenda, the language of the Land Development Code.
Sir, you'll get a chance in a moment. I'll ask our attorney, is the initial request that was approved by the board in 2021, legally, the way the words were written, was it for a garage only or a structure only?
Yes.
Or did it include?
I don't have any, I think you should direct the question to.
We'll concede, I mean, we'll say that it's, the initial approval was an accessory structure.
Yes.
Not a dwelling unit.
Yes.
My point was simply that it does in the application packet, I felt, have enough language regarding a use of this building as a dwelling unit to be comfortable submitting a memo to the county prior to making this application to say, have you looked at this language? You approved this in the proposed use, the proposed conditional use. It says dwelling. Can we just move forward and say we're approved? County said no. Again, we can litigate things all day, every day. Nobody wants to do that. And I think it is clear, having watched the videos and gone back and reviewed and talked at length to county staff about this, that the prior approval was for the structure. Now we're asking for the dwelling capacity.
And Mr. Shack, again, as the director, it's my job, basically, the code gives me the right, the responsibility to try to navigate the right process and the right things. So there was consensus based upon what was approved by the BOA, based upon what Ms. Kim stated, based upon what they got a permit for. They got a permit for an accessory structure, not a dwelling unit. Completely two different permits, two different sets of plans, so they met those standards. So regardless of that, and staff concede, and we understand that she was trying to defend for her client, which she's supposed to. But the black and white language of the approval emphatically and clearly states that what was approved, we're not here to litigate that all day, that was an accessory detached garage. But again, They came in, now they're trying to comply. Will they follow on the mercy of the BOA? I don't know. That's up to them. But this is what we hear today. So we don't have to. The decision was granted. The code speaks for itself. This is where we are here today to see if they met the standards. And staff again said that they does, and it's in the hands of the board to make that decision.
Sir, you wanted to speak again?
Mr. Chairman, before he come up and speak, I just want to just ask if I know this is something that you're real passionate about, sir, but please let's be respectful this morning because we want to hear exactly what you have to say. And I mean, we appreciate you coming out, taking the time to be concerned about your neighborhood.
Yes, sir. The main thing is they're saying that there is nothing else that can be done other than, to grant this conditional use permit. There absolutely can be something done. You can actually take, if you go back to the picture, okay, you can take the windows out of that garage and you can actually put 2 garage doors. You can remove the kitchen, you can remove the bathroom, and you can turn it into a garage. And it's an accessory structure building, just as a garage. That's what it was permitted for. That's what it was agreed to. And again, yes, you can allow him to keep using it the way it is, but unfortunately, he is going to at some point sell this property. And when he sells this property or when someone else inherits this property, it's going to be used as an Airbnb. It's going to be used as an accessory structure dwelling. And it does not, with all of the variances, meet these criteria, and it would have never been allowed to be built. And that's what I'm upset about, is the fact that he has already built 2 properties on a property that was actually 1 originally. And now he's trying to basically turn it into a triplex, which is multifamily commercial zoning. And it's not zoned, that's spot zoning. And I know from a real estate standpoint, I don't want my neighborhood spot zoned into a multifamily. I run a lot of apartment complexes and I don't want multifamily. And what he's trying to do is basically make an apartment complex on a waterfront lot. And it's just, it's not right. He can turn it back into a garage. That's no problem. He can convert that into a garage very easily. All he has to do is take those windows out, put 2 garage doors in, and everything complies. No one keeps mentioning that. So please understand, he can comply with everything that he has. He doesn't have to tear the building down. He needs a garage. But what he wants to do is he wants to basically bamboozle everybody, lie about the permit, and then get into a situation where he can Airbnb it or sell it to someone else so they can Airbnb it. So it's not right. What he did is not right. And please do not allow this to happen.
Board, other questions?
Mr. Chairman, we had another speaker sign up.
Oh.
So
Please state your name for the record, please.
5494 Cruzat Way.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
So
Step up to the mic.
live on the right side, the house that you can see on the right-hand corner. So if this affects anybody, it's me more than probably anybody else. And I just wanted to state that I'm in support with him keeping the way it is. I mean, talk about the size of the lot, like there's plenty of room for the way he has it. He's been very transparent with me with what he intends to do with it. Like when his kids come in town, I mean, there's nothing, he's been a really good neighbor since I've lived there for almost 4 years. He's never, tried to deceive anybody in any way. I have no doubt that what he intends to do with it is what he's communicated. And he hasn't mentioned any ideas of flipping the property and having to worry about that, in the short term. So I didn't come prepared to say anything. I don't know anything about the permit situation. I just wanted to speak to the character of Albert and his wife, and the fact that if anybody should have a problem with it, it's me, and I don't have a problem with it. So, thank you.
Meredith, I have a question for you. If this structure had been built as a garage, would it still been allowed to be used on occasion for overnight guests?
That question, Mr. Chack, that's the question that should come before me. If they do it, it will be on them, but it was permitted as an accessory detached garage. Unfortunately, do people convert those things? Unfortunately, they do, but they are permitted as not a dwelling unit. We want to be clear what the code says, not what they do, but what we permit them as. If there's any issues with that, if code enforcement get involved, then code enforcement have to get involved because there are violations of the land development code, which come under my department, not a lawyer. And of course, they're going to get a lawyer to try to defend it, but the land development code speaks for itself. Do people do it? Does it make it right? No. But if code enforcement get involved, they will have to provide evidence that they are in compliance with what we gave them land use approval for.
And just to kind of piggyback off that, I think, the differences between when someone constructs an accessory structure versus a dwelling unit really comes into the building code requirements, life safety requirements, with the idea that some human person will be occupying that building. And as was stated by staff, building inspections did realize, oh wait, this may be more of a dwelling unit, and it had to meet the elevation certificates for the flood zone. It had to meet other criteria, which it does. While I, again, appreciate Mr. Montgomery's passion and anger towards the situation, it's no different than, if there were garage doors and us coming in saying we want to take off the garage doors and put windows. Do we meet the criteria? County, do we meet the criteria? Yes, we meet the criteria to be an accessory dwelling unit. So while that's not what happened here, yes, we understand the prior permission was for a structure. Now we're saying we want to be a dwelling unit. We meet the criteria of the code. And so by law, if we've met the criteria supported by competent and substantial evidence presented in the record, not the opinions of neighbors, not the objections of the neighborhood. It's not a, public opinion contest or popularity contest. It's a question of law. Have the criteria been established? Then the law is clear. We should be granted the conditional use approval. And again, I do appreciate the last gentleman who spoke to say, there's nothing nefarious, contrary to what's been presented by Mr. Montgomery. We are here trying to make it right. We have, tried to work with the county. We have expressed a willingness. The county didn't come and say, we're going to force you to do 4 times the permitting fees, or we're going to force you. We said, no, look, if we made an error, let us make it right. And so we're just asking to both correct anything that may have occurred prior to my involvement, but also be given the approval that for which we qualify. So,
staff, help me understand again. I know I heard you the first time, but it's a little bit confusing. Repeat what the timeline was with respect to the original construction.
So they came before this board with their request for accessory structure, specifically on the application, mentioned twice in their request for what it was for both conditional use and variance detached garage. Building inspector had gone out there, said, wait a minute, that's not what we're dealing with here. And it went from there. I'm looking at the original building permit, scope of work, for proposed improvements, accessory structure, and then highlighted underneath that, garage building. So, at that point, we were presented, our department and building inspections, with this current situation. Because the differing flood requirements, as I mentioned earlier, we had them secure an elevation certificate on the structure in question, and it did meet the flood requirements. From that point then, we worked, as Director Jones said, we worked with their attorney and have reached this point. This is situation we were handed, and the path we have to put it on to get to where they would like to go.
Let me ask one other question. What, if any, controls are there on this property if it were to be sold and someone decided to make this into a B&B?
So the issue there is short-term vacation rentals. That's a matter for the state. They preempt us on regulating that. Essentially, as Ms. Bush pointed out, if we did not have regulations prohibiting short-term vacation rentals before it was even a thing, we're not allowed to regulate it now.
Okay.
Or the state of Florida.
I can't ask that question. Board, any other questions for the applicant or staff?
Mr. Chairman, there's a hand up. Does he have a form to come up on this matter?
He previously spoke. He had a form. He's your first speaker.
Yes.
Again, Buddy Stromberg, 5671 Cruzette Way. I'm sitting here looking back, reflecting on what went on here. I would like to know how this man got approval to extend his property out into the bay.
Sir, that's not an issue for this board.
Yeah, but I mean, still, you got to have permission to add to your land going out into the water.
Yeah, that's not
Again, it's not under our review.
Oh, okay. All right. Thank you.
Mr. Chairman, after hearing from the attorney and hearing from the neighbors, and I respect every one of the neighbors for coming out today, because they do have valid concerns, and that's whether we deal with those issues or whether we don't. All of their concerns are valid, and it's always good to see neighbors that care. But from what has been brought before us today is we are here to decide whether it meets the criteria, and they have met each item that they should have met this far to come before us. And I regardless of how I feel personally, there's so many people that they do bamboozle people and use the law to get away with it. But I can't sit here today before you and accuse this neighbor of that. I would be dead wrong to do that. But they have met the requirements, and it's our job to approve these items when they have met the requirement, regardless of how we feel personally. So with that being said, if there's no further comments or questions, I would like to put a motion on the table to approve according to staff's findings, because they have met all the
Before we have the motion, I'd like to have a board opportunity.
Yes, sir. Yeah, most definitely. Most definitely.
Board, any comments? Okay, Willie, go ahead.
I would like to make a motion to approve according to staff's findings, and that's it.
I'll second it.
We have a motion by Willie and a second by Ross. Yeah. All those in favor of the motion, please raise your right hand. And it is unanimous. The motion passes. All right. We have case number V2026, I'm sorry, V2026-01. Thank you. Okay, 5490 Cruzat Way, a variance request to allow a side yard setback variance requested by Meredith Bush, agent for Renata Chedwick, owner. Board, is there any ex parte communications regarding this case? Seeing none. Board, do any of you have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium? And it's Ms. Bush, and you have been sworn in.
Yes, Meredith Bush, 314 South Balin, Suite 108, Pensacola, Florida, 32502.
Okay, would you like to present?
I'm happy to present. So this variance request relates to the Cruzat Way property that we have just gone through the conditional use on. The reason for the request is that the setbacks in the code are different when you're dealing with a structure versus a dwelling unit. So because now the conditional use has been granted, the current setback, we need an increase, I believe it's of 20 inches. It's 1 foot 8 point some odd, 1.7 feet increase because now it's a dwelling unit. While there are some differences in our findings and in staff's findings, and I will say that I did submit a revised narrative to the county this morning because the initial narrative that we submitted, I had written in it that the prior variance had been approved. It was the prior conditional use that had been approved. So I've submitted an updated narrative just outlining that the prior variance request on the structure had been denied. However, here we are today with an approved dwelling unit. We need an extra 20 inches from the setback. And so going through the criteria, it is our position that special conditions and circumstances exist. The parcel is a waterfront lot bounded by shoreline constraints, floodplain considerations, and a limited buildable envelope. Again, the structure is already there. The structure exists within a building footprint. It has been constructed and inspected by the county. So we're not seeking additional encroachment, but just acknowledging the location of the structure. As far as whether or not it's a result of our own actions, strictly speaking, the owner did construct the building there. However, the need for the variance is a result of the change from it being a structure to a dwelling unit. There would be hardship from strict application. So strict application of the setback requirement would create an unnecessary and undue hardship that would effectively prevent the use of this structure as a dwelling unit. Because the building is already in place with some prior approvals, enforcing the current setback requirement would deprive the property owner of rights commonly enjoyed by other MDR-zoned properties, namely the ability to utilize the structure as an accessory dwelling where otherwise permitted by the conditional use. Again, the conditional use which we've just been granted. The requested variance is the minimum relief necessary to allow the use as an ADU. No reduction beyond this existing 4-foot setback is requested. No expansion, additional encroachment, or alteration of the building footprint is proposed. The variance would align the ADU designation with the already constructed setback condition. And then consistency with the intent of the Land Development Code. It's our position that granting the variance is consistent with the general intent and purpose of the Land Development Code and will not be injurious to the surrounding area or detrimental to the public welfare. Recognizing the setback for ADU purposes would not alter neighborhood character. It's not going to impact adjacent properties or increase intensity. The variance supports orderly development, respects reliance on the prior approval that you've just given us, and facilitates, flexibility in design consistent with the district. Unfortunately, denying the variance would produce an unworkable result of approving the conditional use, but rendering it unusable due to the technical setback issue, again, of about 20 inches. So we are asking that you accept our findings submitted in the revised narrative today. Happy to take any questions. Again, we've expressed a willingness to pay up to 4 times, which I believe is the maximum the county can impose for the permitting fees, and would ask that you grant the variance to allow the conditional use that you just granted to be in full force and effect.
Board questions for Ms. Bush?
Mr. Chairman, will you have a vote to accept her revised narrative for her case?
I'm sorry, say again?
She is submitting an amendment to her narrative, and we need to accept it into evidence because she had that error on there.
We need a motion on that.
I make a motion that we accept the narrative, or the amendment to the narrative.
Motion by Ross. Second by Greg. All those in favor of the motion, raise your right hand. It's unanimous. Okay. Questions for Ms. Bush? All right. Staff, would you go through the findings of fact?
This is case V 2026-01-5490 Cruzette Way. Requested variance to the applicable right side yard setbacks allowed by the LDC. We will go through all the criteria and finding of facts. You want to go straight to? So criterion 1, special conditions and circumstances that exist which are peculiar to the land, structures, or building. The applicant is requesting a variance to the required right yard setback for the now existing accessory dwelling unit as opposed to the accessory structure that was previously submitted. So the ADU, the dwelling unit, right now it does not comply with the setback requirements applicable to the principal dwelling, the main home that's on the land or lot right now. The required, and I'm just giving an example of the required setbacks right now in this finding of facts. It should be, the lot is 82 feet wide. For a dwelling, it should be at 8.2 feet. Had they came to the county at the time or previously and requested, we are able to give, front counterplanners are able to give a 20% variance to that. That would have taken them to 6.5 feet, which I believe they got on the main dwelling, on the main home when they were building that. And per their existing survey, their sealed survey, right now the ADU is at like 4.76 feet, okay? So the Land Development Code says 10% of the lot's width, no greater than 15 feet, no less than 5 feet at the minimum. So that's why we're here, they're requesting this variance to comply with the dwelling right now. Therefore, the variance of, like Ms. Bush said, 1.74 feet is requested, which basically is about 20 inches or so. Special conditions, the special conditions and circumstances does not result from the actions of the applicant. Finding of facts. Special conditions and circumstances necessitating the variance, in staff's view, findings. They are the result of the actions taken by the applicant, therefore this criterion is not satisfied. Initially, again, it was submitted and built, was supposed to be a garage, and now, which in fact it was not built as a garage, it was built as a dwelling. So that's why we find that it is the result of actions taken by the applicant. Criterion 3, granting the variance requested will not confer on the applicant a special privilege that is denied by this land development code or other lands, buildings, or structures in the same zoning district. Finding of facts from staff, granting the requested variance, it would confer with a special privilege by allowing development standards that exceed what is permitted for other properties within the same zoning district. Criterion 4, strict application of the provisions of the land development code would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the land development code, and would create an unnecessary and undue hardship on the applicant. The need for the variance is the result of the actions taken by the applicant on site. Therefore, the application of the land development code does not create unnecessary or undue hardship as defined by the variance criteria. Criterion 5, variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. Based upon the criterion stated above, the location of the proposed structure or the existing structure as submitted, the requested variance, it exceeds the minimum relief necessary as reasonable use of the property could be achieved without granting the variance. So, you know, since the conditional use has already been approved for an ADU, they can still achieve that, even if the variance is granted or not. Criterion 6, granting the variance will be consistent with the general intent and purpose of the land development code, and that such variance will not be injurious to the area or otherwise detrimental to the public welfare. Finding of facts, granting the requested variance would be inconsistent with the general intent and purpose of the land development code and may have adverse impacts on surrounding properties, but it would not be detrimental to public welfare. Staff recommendations, based upon the review of the land development code and the variance criteria, the staff finds that the requested variance, it does not satisfy the requirement standards. And that's conclusion of staff findings.
Questions from the board or staff? Would you scroll back to the variance? All right, if I understand this right, it's starting to get complex here to me. What would the setback have been if the initial request was for a garage only or structure only?
So that would have been 5 feet.
Okay.
5 feet for just a garage or an accessory structure.
Okay, and as a accessory dwelling, what would that setback be?
So it would have been 8.2 feet because the lot is 82 feet wide. Again, it's 10% of the lot's width, no greater than 15 feet, no less than 5, whichever is less. So it would have been 8.2 feet. If they weren't able to meet that, again, they could have come into a front counter planner and requested a 20% variance, which we're able to grant at the front counter of 20%. That would have taken them down to 6.5 feet, which is, they did grant that on the main home when they were building that, and we did grant them that. But again, at the time, this was, you know, a garage and not a dwelling, so it would have taken them to 6.5 feet.
So staff, basically what you're saying is if it had remained a garage, that it would have been okay.
Yes. If it's just a garage, the setbacks, they would have complied with the side yard, that right side yard setback, yes.
Thank you.
So let me get this straight. If the initial request was for a garage only, and then it was changed as per the previous case, became a dwelling, it seems to me that the applicant is using or used the structure to get the setback as much as he could and got it. And now with this request, he's asking to change the setback some more. And does that make it that the structure right now is over the setback limit?
Correct. So the structure right now as a dwelling unit, it's non-conforming. It's not meeting the minimum setback requirements.
Okay, that's clear.
Questions, Chairman? Could we scroll back down to the staff's recommendation, please? So my understanding of the staff recommendation is it's a conclusion. What is the staff's recommendation as far as the request goes?
As far as the request goes, the variance does not satisfy the requirements as far as a dwelling. That's why they're requesting the variance. They don't. It's denied. I'm sorry. Yes.
Thank you.
Satisfied. Yeah.
Thank you.
Does that mean, I'm confused now, since we.
And now this is the thing, okay. Nonconformity does not mean that it cannot be no ADU. Let's be clear.
Yeah.
But denying of the variance, it may, I don't know how it may impact the insurance, all the other type of stuff. It does not say that they still, because we already granted that permission, but they will be set back, whatever it is, and it would be a non-conforming ADU. Now, it does not also, it does mean that it doesn't, they create the hardship, but does it impact the surroundings? Is one of the criteria? Those are things you have to look at. Those are things you have to look at.
The staff's recommendation was purely from a viewpoint of code.
Of the code, of the black and white language of the land development code only, the technical requirements, numbers, and the facts as presented.
What would be the result if the board were to not approve this request?
I drew commentary on that.
The building would have to be modified.
Yeah.
So it's approved.
For it to be used as a dwelling, it has to meet the setbacks for a dwelling. Our approval originally was for the setbacks for an accessory structure. There would be modifications necessary, either to moving the building to meet the setbacks or making it a garage. I mean, it's just, that's the situation we're left with.
Because we would not be able to get them we would not be able to give them managed approval for that ADU and meeting the setback requirements. But it does not comply. We'll have to make modifications. Whatever that may be.
This irritates me a bit. We saw on the previous case that it was questionable how the process or what the intent of the owner was, but the process was correct and we approved it. But now it's happening again, and it seems like to me that the client, or the owner, has put us in a bind.
Mr. Chairman.
Now there are penalties. They're agreed. Now there are penalties. Penalties. That is your choice, but there are penalties. Like code enforcement, people. I'm not trying to defend them at all. Just trying to put some logic behind it, from a rational perspective and thinking critically. People violate, unfortunately, and it's wrong, violate our land use code all the time. Unfortunately, doesn't make it right. No, That's why they come for the code enforcement. If there's a code enforcement assessed penalty, they get it. Tear it down, remove, or they pay fines. Tear it down or remove, or they pay substantial penalties because of they broke. They are not. I don't want to say broke the law, but they did not adhere. So there's a consensus. They will pay 4 times the fee. Does it make it correct? No. But thinking from a logical perspective, not trying to defend them, just trying to be open and honest, because that's my job, to be open and give you all of the facts. There are penalties that could be assigned. And modifications can be made if you so, and they stated they're willing to pay 4 times the fee.
Mr. Chairman, I agree with you. It reminds me of what goes on in the dark comes to light. And, you know, I'm very plain when I speak up here. I'm not all proper and all of that. So I'm just being real. They met all the requirements in the last case, and we're not on the last case. So, but I'm just saying that's why I supported the last case. But they do not meet the required standards on this case, and I'm gonna stick to it. I'm gonna do what's right, and at the end of the night, I'm gonna sleep good. And I can't support this because it's not right, and they don't meet the required standards, and I'm not gonna bend on it. So that's just my opinion.
Thank you. Other comments?
I think the staff has done an excellent job with this.
Thank you.
This is a complicated situation, and I'm a very ardent supporter of staff's recommendations in matters like this. So that's my position on it.
Thank you. Other comments or follow-up questions?
I'm sorry. I'm agreeing with everybody. It's kind of an ugly case, but if we just approve it to become a dwelling, this variance now makes that last decision kind of useless if we don't approve.
Well, as I understood from staff, they would have to modify the building, which I envisioned as chopping off a couple feet of it so that they do make the setback requirements.
You know, I feel like if they had been honest about it being a dwelling in the first place, well, maybe we'll say maybe they did make an honest mistake, but you know, it don't sound right when you say you're willing to pay 4 times, you know, the amount, to do whatever. I mean, if you're willing to pay 4 times that amount, I mean, just modify the home or the building and just make it right, because you know, it doesn't satisfy the required standards, and I just can't support that. You know, I'm sure a couple of neighbors or maybe one that left out of here on the last case, probably angry as I don't know what with me because I made a motion because they met those standards. But I'm not here to satisfy everybody or, you know, just because somebody can throw $1 at a fine and make it right. You know, what about the people that can't throw $1 at that fine and make it right? You know, we have to be fair all across the board, and this just does not meet the required standards. And I cannot support that. I just can't.
Go ahead.
Go ahead.
If I may just respond to some of staff's findings and some of the concerns of the board. You know, as has been stated, the reason for the variance is because of the conditional use that we were just granted, because of the use as an accessory dwelling unit. The structure already exists. While I understand the idea that it's not the minimum if the property can be used for anything else, it is the minimum to use the property for the allowed, permitted, now of right conditional use that was just granted. The reduction is the minimum. You have to have the setback reduced to be allowed to use reasonably as an accessory dwelling unit. You know, I don't know the cost that it would take when you talk about modifying the building to remove, you know, 20 inches. you know, I'm not a contractor, I don't know what that entails, you know, but if you're talking about demolishing a structure, obviously that's, you know, quite a substantial hardship someone would face over 20 inches. When you're talking about, you know, moving walls or roofs or whether or not it could have an overhang or if there can be nothing at all in that setback, actually physically moving the structure, it's not a house on blocks or off grade, it's on a foundation. And so the exorbitant cost to do something like that, while not an issue in this matter the same way it was in the conditional use hearing, you know, there's a willingness, if we needed to record a private covenant and restriction to say no short-term rental, no, I mean, there's willingness to work with and, you know, have conditions imposed on the use. Again, that's not a technical criteria in the code. However, you know, to the extent that we can make it right, to the extent that we can establish that because of the conditional use that you've granted, this is the minimum. Because of the conditional use, there is a hardship imposed by the code language, not by the applicant. Now, I understand the concerns over the history. Again, I wasn't involved. I don't know, you know, what decisions were made or what advice was given along the way to get us to this point. But we're here now, and we have the permission to use it as a dwelling unit. And so a 20-inch variance to allow that use of the property, you know, does appear to be the minimum. You know, we have offered alternative criteria, and, you know, I believe staff can vouch for the fact that I, you know, typically fully support staff, and we work well together. You know, I've worked with them for decade. I mean, it's been a long time, you know, as prior counsel to the county, very familiar with land development code regulations. And the idea that the black and white is the only way to make the decision, you know, I would respectfully disagree with that and say that you do have some discretion. Like, you do have the ability to say, you know, while perhaps the path to get us here is not, you know, what we would have written at the outset, if we could go back and do it over, we're here now. And we have an existing structure here now. We have an approved dwelling unit use here now. If it makes a difference that we voluntarily deed restrict and say no short-term rentals or something like that, again, that doesn't change the criteria in the code, but if that alleviates some concern over there's a nefarious, we're getting away with something, oh, now we've gotten away with it, we'll voluntarily do that to remove that concern, to say, look, this is, you know, it truly is a structure that was intended to, you know, when overnight guests come, sons from out of town come in, to have them a place to stay. And that's the only intent. You know, we've already filed that information with the county and recorded affidavits to document that. But if we need to go a step further and deed restrict through a private covenant restriction that would run with the land to say, you know, this is the purpose. Yes, it's within the setback. But the only reason for the difference is it was brought to our attention, look, you're not, you know, you need to correct this, so we're here trying to correct it. And so while, you know, I understand why you're taking a hard line and absolutely respect the difficult position you're in 100%, respect it, you know, appreciate the hard work that you do. In this situation, we are asking for grace, and we are asking for you to, you know, make a concession or have a willingness to accept our findings and work with us. You know, you tell us what we need to do to get the approval, because I believe that there is a path for you to say, well, they do meet the criteria, and we do find that while is it an act that we asked for the dwelling unit? Yes, that's an act of the owner to say we want to be a dwelling unit. But is it, you know, should that rise to the level of being denied the variance because, you know, it was imposed by us wanting to convert what was previously a structure into a dwelling unit? You know, I don't know that that's necessarily the true intent of the Land Development Code, not to grant permissions in situations like this. It's a very unique situation, and I understand it's a difficult decision.
All right, do we have a Mr. Montgomery present? He's gone? Okay.
Mr. Chairman, can I comment just back on what she spoke on? as far as putting it in writing, that there won't be any short-term rentals or whatsoever. According to the last case, you said that that's nothing that nobody can control pretty much.
You get it in writing.
Right, you can't, so the government, the county can't tell us to do it, but a person who owns property can restrict their own use. So it would be a self-imposed voluntary, restriction that could be enacted to say, look, even though we have the right and the law says nobody can tell a person who owns residential property that they can't rent it, if we want to, it's sort of like an HOA or some entity, if it had gone into effect prior to, or if everybody just voluntarily agrees to it, then that can be effectuated. And I apologize if that wasn't clear before. I thought you meant whether or not there was something that the county could do through the conditional use process to stop that, and there would not be. The county couldn't impose a condition of a conditional use to stop it.
All right, thank you.
I apologize if that wasn't clear.
I appreciate it.
Willie,
Go ahead.
I don't know that. There we go. My question for that is, I'm still leaning towards what we've talked about. This just does not fit the land development code through errors or mistakes. But at any rate, in the event that we do place a restriction, how do we ensure that that is part of the title work so that whoever they sell it to, that conveys with that property into perpetuity?
Right, it would be recorded in the official records of Escambia County through the clerk with the property reference number, and so it would come up in any title search. In the same way, when you purchase property at an HOA, the covenants and restrictions that put everyone on notice, this is what you can and can't do, we would effectuate that.
Okay, and in the event that the structure was destroyed or demolished, or a percentage of it was destroyed in a storm, could it be that it could not be built back on its same footprint?
I believe we could make that agreement. I don't know that the variance typically would.
Well, if something destroyed by act of fire, we always try to get it to comply by those things. If it cannot, of course, it can go back to the same structure. But if they want to put that in there, those things runs with the land. Now, we don't enforce the land, and we don't enforce those requirements. But that is something, and they have, and if they want challenge, covenants and restrictions, they have the tendency to go before the court and stand.
I would be willing to do that.
As Director Jones pointed out, variances are based on unique physical hardship on a unique piece of property, so they run with the land. It could, a storm could come, it could disappear. The variance still stays with that land.
All right, we have another speaker. I can't read this copy. Albert, his first name?
Albert Schwedzuk.
Please raise your right hand.
5490 Cruzat Way.
Thank you. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
So I just wanted to clear our name of being called liars 5 times today by the person which was so proud he owns 270 properties in the state, and I know for a fact he don't even live on the Cruzat Way. It's just one of his properties. But when we start building this 2 buildings, original idea was, yes, to have the main house and a garage on the same property. When we started the building, we sold everything in New Jersey we has, and we moved here full time. Now, we ran out of the money halfway done, so we has no option but move into that garage building in the meantime, when we're still finishing the main house right now. So that was that's the whole story. Now, about this variance, in my in how I would see it as the next door neighbor is, we're talking about the 20 inches difference of the border. And as we was a garage building, which is 12 foot high, that building would sit exactly the same distance as it's sitting right now. So if we call it now dwelling, it's still same distance, so would not change anything to that next door neighbor, because the garage was built at 5 feet from the border anyway, and it stays exactly the same way. So what I'm trying to say is it was approved to be 4 or 5 feet away from the border as the garage, but right now, after we changed that to the dwelling, you know, how it doesn't make any sense. You know, like me being my neighbor, looking at the garage wall, what's called garage with a through windows, or dwelling with a through windows, it's still 5 feet away. And if I'm gonna have to move that, rebuild this house 20 inches, this is like a completely rebuilding the entire building. It's like, you know, we're never gonna finish our main house.
And members, and we're now, and the board, you do have discretion. That sometimes the code is black and white, but then that's why these boards are here for, amen, to try to put some grace, if there's grace to be given, to try to add some other alternative methods. That's the purpose of these boards. Everything will always fit within it should have in a perfectly square box. In this case, it's very complicated. It's very complicated. We have to stand by what the code says. And sometimes we do like soft approaches, because sometimes the code is not as always as bendable or pliable. That's why land use is very complicated, complex science. That's why these boards are in place to try to add some soft skills. But y'all have overturned our decision before. Y'all have granted those things. Thank you, Mr. Thank you for always supporting the board. But sometimes grace and with these language, it makes it complicated. I'm gonna try to defend them? No. I'm gonna try to provide some logic and some purpose and give you some understanding. Yes. That's all I'm doing. Not trying to abide by nobody. It's still your decision. Sometimes things don't always fit into a perfectly square box. And I have to take my feelings out of it, because sometimes I want it to.
I totally agree with you. And grace, you know, we've talked about that many times before here. And I do believe in grace. But I do also believe that every situation in our lives are not one size fits all. And I still stand on my decision. I would not support this. I did support the other one because you guys met every requirement, and I did the right thing. And I'm going to do the right thing on this one, and I'm not going to support it because it does not satisfy the required standards.
Just following up on Willie's comments, my understanding of the process is that our job is to make a decision based on the evidence that's presented. My understanding is staff's recommendation and conclusions are evidence. My understanding. So from a human, that aspect of it, I have great compassion for this couple here, but that's not my job. Mm-hmm. My job is to make a decision based on the evidence presented, and that's what I intend to do.
Any other comments?
Just one more thing, and I'm not going to prolong it, but there have been a lot of decisions made in this county alone, all over the world, decisions, and it has been too much, not too much, it's never too much grace, but people bend, you know, they bend because somebody can throw $1 at something and make it right all the time. You know, that's not even the case here, you know. I meant today with this particular case, that's you know, we have many cases, and yes, sometimes we do go against staff findings, but this is clearly something that I mean, I don't want to bend today on this particular case that we're on right now and be responsible for something 10 and 20 years from now. I'm not going to do it. And I mean, I just do not support it. And I mean, unless, like my colleagues say, you know, we're here based on the evidence to make this decisions. Unless you have some more evidence that clearly states you meet those required standards, you know, today is not a day where, you know, today I just can't support this at all, and I'm done.
Thank you, Willie. I'm going to make some final comments also. One thing we have to look at is whether or not several years ago this board made the decision to approve construction of structure, and with that came the setbacks. If the applicant would have asked that board to adjust the setbacks, lessen them, would the board have approved that, or would the board have said, no, you have to meet our setback requirements? So now we come to today, and that question is being asked again. Only this time, the structure has already been built and imposes on the setbacks, and it's put the board in a position of as Willie said, not only what could happen in the future, but would we have, we followed the law, we followed code, and we've been requested to make a change in our previous decision. I've been on this board for 5 years, and one thing that Mr. Jones has mentioned over and over again is sometimes there's compromise, and that's different than grace. Compromise is when both parties agree to give up some things and take others. There is no compromise here as far as I'm concerned. The applicant either gets the variance or the county says no, it doesn't fit their criteria. And I don't see any way of compromising at this point. So I'm in agreement with Willie that this request, as per the staff recommendation, does not satisfy the required standards.
One additional thought that I have, I appreciate, you know, your statement that unless you have additional evidence to show, I would ask if the board would consider delaying the decision. I mean, I can see the writing on the wall. You know, I can count votes who have spoken and allow us time. The staff, you know, we submitted the conditional use criteria or application after representation that staff would support it. It was only very recently, prior to the hearing, that the staff came back and said, oh, by the way, you also need a variance. And so allowing us additional time to work with the staff to see if there is any other evidence out there, anything else that we can submit to supplement our presentation, rather than having a decision today, if the board would consider allowing us to come back, you know, next month or the month after to complete the process.
For the record, she did ask me that, and I did tell her, for the record, to ask the board. That's not mine. I want to be clear for the record. Okay?
Yeah.
Like to be clear.
Mr. Chairman?
Would that request require a motion and a vote? All right, any other comments before we?
The only comment I would like to make before there's a motion and a vote is, I feel like that is fair. Because today there is no evidence. And I feel like they should be allowed the proper time that's needed to provide evidence if there is some, to come before the board. And,
Other comments?
So just to clarify though, are you suggesting withdrawing the application?
No, not necessarily withdrawing, but it would just a continuation of the hearing. You know, we would come back. It would just be part 2 of today's hearing. We wouldn't have to go through the presentation again. If there may be nothing else we submit, there may be something we submit. There may be some creative solution out that we haven't thought about. There may be case law that I haven't found. But no, it wouldn't be a withdrawal. It would simply be delaying. You know, we table it where we're at now. We come back and pick up where we've left off, and your decision may be the same as I feel like it's going. It may be different, but it would allow us time to, and that consideration would be, as I stated, and I don't know, it was a couple weeks ago that the county came back and said, oh, you also need a variance, and we need your, submission by, in 2 days or something like that. So it would just allow us a little additional time to see if there's something else that we can provide.
Okay, then yes, I do believe that requires a motion, and also I think for staff's sake, you should address who will pay for the advertising costs.
Yes.
Okay.
To notice the continued hearing.
Can I have a motion to table this case?
I would like to make a motion to table this case at this time and for the landowner to pay for all costs, advertising or whatsoever. And
would this be on the next BOA agenda or?
Maybe the one after. I don't know what the deadlines are, but March 18th.
Okay. So I make a motion to table this item until March 18th at the expense of the owner.
Do we have a second?
Second.
Motion has been made and seconded. All those in favor of the motion, please raise your right hand. And it is unanimous.
Thank you.
All right. Let's get back to where we are. All right, do we have new old business? I have a bit of new business. Please don't be shocked at this, but I have submitted my resignation. I've been on the board for 5 years, and I feel that's long enough. And I've really enjoyed being here, even though we sometimes have very difficult situations to work with and can be stressful. But it's time for me to step down as chairman and get off the board. So as of right now, I am off the board.
Thank you for your service.
Certainly.
Thank you.
Thank you, Marty. Mr. Jack, as the director, I've worked with you for many years, as well as Mr. Drew. We appreciate you for your consistency. We appreciate you for your service. I don't recall too many times where you have not been present. You saying you helped our staff become the staff that it need to be. And looking at all of these matters, we appreciate you, and I'm not a liar. We appreciate you for your service, and we thank you tremendously.
I appreciate the words. I too have been very pleased with staff's work. I know if I think this job is difficult, yours is much more difficult. And the fact that you have given the board the opportunity to make good decisions based on input from you, that we have a good working relationship, and I hope that continues. Thank you much.
Thank you for your service. It's been great serving with you. I'm getting a lot of wisdom from you. Trying to figure out now, do we make a motion for a new chairman now, or we have almost everybody here?
If you want to address that today, you can, or you can wait if you think everyone might want some time to consider who may be nominated. It's entirely up to you if you want to address it now or later.
I'd like to address it now. I mean, I
agree.
Honestly, I'd like to nominate Mr. Kirkland as the new chairman. He's the one with the most experience and probably the most temperament.
I second that.
I just want to say thank you to all of you. This means a lot to me. I've been on the board since 2019, and we've seen a lot of situations come before us, and we've seen a lot of concern from the community. And it makes me excited when the community comes out and they voice their opinion, whether they're mad, sad, or happy. And, you know, we can't please everybody, but one thing that we're going to continue to try to do is follow the rules and make this community better in the future. With that being said, you know, I was the vice chairman, so now, you know, I want to leave it up to the board to decide what we're going to do about vice chairman. Is it legal for me to make a motion for vice chairman?
Well, that's confusing because now you're technically both chair and vice chairman. So I might leave that to someone else.
Can I comment on it?
Sure.
Okay. Well, I'd like to leave it to my colleagues on vice chairman, but I would like to comment on it. I'm not going to vote on it, but well, I can vote on it. Okay, but I won't make the motion on it. But you know, Ross, he has been here with his coffee. I used to joke with him. I say, "Is that really coffee in there?" But it's coffee. But he has been here, and he has been faithful, and so that's just my suggestion.
I'd like to make a motion that we nominate Ross as vice chair.
I second that.
All right, we got a motion and a second. All in favor? All right, it passes 3. Well, you can vote. You don't want to vote?
Vote for yourself, Ross.
I'm worried about that if you don't vote for yourself. Motion passes unanimously. Yeah, I got to work on that word, but y'all get it. But thank you. But so is there anything else, any more older new business that we need to discuss before?
I will just say that the next meeting is going to be Wednesday, February 18, with a minimum of 4 cases. And I really hope all 4 of you will be here to make a quorum next month. I have Marty's position open and is being advertised. I have not received any applications, so if you know anybody that may be interested in this role, let them know to email me their resume.
All right, thank you.
It's an at-large position.
Anything from you? Okay. That's it. This meeting is adjourned.
Good job.
It's awesome.
You've done it.
Good luck to you too.
Pray for us.
Sorry to surprise you. with that.
No, I am surprised, but congratulations.